Officer Day, would you open our courtroom?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Mr. Rusin, good morning.
Morning, Judge. I don't have anything on your docket, which is why I'm sitting in chambers doing my chamber work today.
Okay.
I have a quick question for you administratively. Do you mind if I interrupt you for 2 minutes?
All right, go ahead.
I'm sitting here and my staff has brought to me as I sign my 36th District Court defaults. Now, my staff is currently attaching to the default copies of the proof of service of the summons, which I show that was originally filed separately and should be in the ROA. My staff is also attaching as additional papers, usually 1 or 2 pages from the U.S. military website that shows that or verifies if the individual is currently in military service. Now, here's the purpose for me calling you. You may be interested to know that the cost of a ream of paper for me has increased threefold, 3 times since 2020. So I'm trying to reduce the paper. And my question directly to you is this, which I'm very interested to see your response. If I've already filed the proof of service of the summons and complaint, it should be in the ROA. I don't see as a plaintiff's attorney the need to attach it to the default judgment that I file separately. Also, if on the scales form, the default is having me check a box and then sign under oath under notary that the defaulted party is not military service, it seems it seems unnecessary to attach another 2 pages to the default pleading that shows that the defense is not in the military service, because I'm already signing that under oath, under penalty of perjury.
Well, here's what I would suggest, and you can do whatever you choose.
Yeah.
In regard to the proof of service, if you have filed a proof of service and summons and complaint, and it appears on the register of action, I would assume it was in the file.
Yeah.
Now, if you are looking to have a default judgment entered, I would behave differently if I were looking to have a default entered. If I'm looking to have a default entered, it would be useful to have all of the, because I would be useful to have all of the necessary proofs for the default. If there was an order for alternate service, if there was a posting order, if there was posting, if there was first service by mail. And in regard to the the SCAR, there are 2 separate things going on here. The form was revised effective in September of 2022. Many offices, including yours, use both the old form and the new one. It is only the form that was revised after September that has a verification of the SCAR check and there being nothing done. My advice would be, given that lawyer time is much more expensive, even support staff time is much more expensive than a piece of paper, I would have everything submitted along with my request for default, even if it's not necessary. Because what's going to happen is that if it gets separated somewhere in the process, and you've seen our mail room.
Yep.
And we get more mail in the damn post office. I'd be careful. So my recommendation would be that if you're looking for a default, you send in with your default everything necessary to support it. Once your default has been entered, then of course you must serve the other side and file proof of service of that. Right. On my default judgment, I would send in only my default judgment and my proof of my default, because by that time the court will have served the default and you will have served that as well. So I wouldn't duplicate it with the default judgment, but first time out, I would think that lawyer time, staff time is going to be much more expensive than a ream of paper.
All right, Judge, you've been very helpful. I will explain it to my staff.
Okay, have a great day.
See you. Bye-bye.
Thanks. Mr. Barter,
Good morning, Your Honor.
morning. I don't have an opponent for you as of yet. You got portfolio recovery versus Mickey Ellis.
I do. I also have portfolio recovery versus Lanice Cobb.
Okay, I don't have either one of those people here yet.
Ms. Cobb signed a consent judgment that we've already forwarded to the court, completely executed.
All right, let's get that file up and get that taken care of right now. 078. We are on the record calling file number 22198-078, portfolio recovery versus Lanice Cobb. Date and time for pretrial, your appearance.
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of Portfolio Recovery Associates.
Mr. Barter, you were saying that this matter has been resolved and consent judgment forwarded to the court.
That is correct, Your Honor. We got in contact with Ms. Cobb. We sent her a consent order for judgment with installment payments. She has signed it, sent it to our office. We have executed it and forwarded it to the court. I just don't believe it hasn't made it to the file yet.
We accept your representation as an officer of the court. I enter a dismissal without prejudice, noting that a consent judgment is to follow.
Thank you, sir.
Put you back in the waiting room for your other file.
Perfect. And I think I also have, just so you're aware, do I have an 11 o'clock credit acceptance versus Jacqueline Wilson with you?
Yes.
Okay, perfect. Thank you.
Good morning, Your Honor. How are you?
Good, counsel. How are you?
Not so bad.
It's Friday.
We're almost there. Almost there, Judge.
Hello,
Yes, hello.
you have video?
I think so.
Well, you need to turn the video on.
Okay, how do I do that? Oh my God.
Are you on a computer?
Yes, I'm on a laptop, but it's saying it's unable to, let me see. Zoom is unable to detect a camera. Make sure that your camera is,
That's your camera.
yes, connected to your computer. This is a new computer. I don't know.
All right, we'll get started without it. You can play with it later.
Okay.
We are on the record calling file 22196-000 Nationwide Mutual Fire Insurance versus Sherry Hodby. Date and time for what appears to be our first pretrial in this insurance subrogation action. Could I have your appearances?
Good morning, Your Honor. Abe Newhouse here on behalf of plaintiff Nationwide.
You remember the State Bar of Michigan?
Yes, Your Honor.
And you probably have a P number.
85687, Your Honor.
And tell us your name again, ma'am.
Sherry Hobby.
Is it your intention to represent yourself in this matter?
Yes, I guess.
You have an absolute constitutional right to do that. What you do not have is to write your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you'd like to represent yourself, as is your constitutional right, the same rules that bind Mr. Newhouse are binding on you. Do you understand that?
Yes.
All right, where are we on this file, people?
This is our first pretrial, Your Honor. Discovery hasn't been opened. Based on the representations in Ms. Hovde's answer, it looks like we're headed towards a motion for summary disposition.
Okay.
I would ask for written discovery, just to clear up any question of fact.
All right, this is what court's going to do. I'm going to open your written discovery at this time. I'll give you a return date. Your return date with me will be Friday, February 10 at 10 o'clock. Does that work for everybody?
Yes. Hold on.
Yes.
Okay, Friday, February the 10th.
At 10 o'clock, yes, ma'am.
Okay.
Okay,
If I may,
sir.
Ms. Hovde, if you want to reach out and to my email address, which is on the complaint you should have got, and you want to settle this matter, feel free to do that at any time, okay?
Oh, okay, that's fine.
Okay, let's do this. I'm going to send you guys out a written notice of that pretrial. Right now, I'm going to put you into a chat room so you can talk about your case. If you're able to settle the case, come back to me. If not, we'll be together next February 10th at 10 o'clock, and your written discovery is now open.
Thank you.
Let's see if I can make the technology work and get you guys in the chat room to discuss the matter.
Thank you, Your Honor. I appreciate it.
See how the breakout rooms work. Okay, hang on, let me get you in there.
Oh, geez.
Room 2. Room 2. He's gone. All right, you want to join, ma'am, where it says join the chat room. Just click that. There you go.
Morning.
Good morning. We are on the record. This is file 22192. I'm sorry, 22195-288. Portfolio recovery versus Mickey Ellis. Date and time for what appears to be our second pretrial. Your appearances.
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of the plaintiff.
And what is your name, ma'am?
Mickey Ellis.
Okay. This is our second pretrial. The last time we were together on December the 9th, the court opened your written discovery. Since that time, a motion for summary disposition has been filed on behalf of the plaintiff. So my first question is, how is your written discovery coming?
Well, actually, I have been trying to contact the attorney, Mr. The attorney. Yes, about, because he said the last time we spoke, he said he was going to give me a call because he was going to talk to the plaintiffs about the funds being released. He did make an offer. I mean, not funds for me. I mean, he was talking about the funds.
Settlement funds, okay.
Yeah, settlement. But I never received anything.
All right, let's stop right here. Y'all need to talk in the chat room?
We can speak. I have no issue with that.
All right, let's do that and come back to me when you're finished.
Perfect.
Okay, now let's see if I can make the magic box work today. All right, let's find breakout room. And we're gonna put Ms. Ellis in room 1. Mr. Barter in room 1. Barter. You're gonna have to hit the join, Ms. Ellis.
Oh, okay, sorry.
Says where it says join, click on that. That should take you to the chat room. There you go.
audio around was our piano center. That center, when Giovanni variations, we took tunes, arranged by every Chopin, midday music open today. This was WRCJ, I don't think HD1, but it's really. Support the WRCJ, provided by the William Davidson Neighborhood Concert Series. Enjoy the full orchestra of the workouts from your. And my Saturday neighborhood. Tickets available now at DSO January 15th in Southfield, Monroe, Beverly Hills. Speaking of, I can workout, that was check speed where you would just about 10 minutes right after this function of the other picture of the person. I like this for 2020.
All right. Mr. Barter and Ms. Ellis, we
Yes.
are back on the record in 22-195-288, portfolio recovery versus Mickey Ellis. What's going on, folks?
Your Honor, we're still talking. Hopefully we can get this resolved, but at this point, I think we would need a motion for summary disposition date, at least from plaintiffs. I think discovery, we've never needed discovery, so we're still in the position that we don't need discovery. I don't know if defendant wishes to keep discovery open, but.
All right, Ms. Ellis, are you intending to do any written discovery?
Well, I know that, I'm sorry, but I don't understand what that means.
Written discovery is your opportunity to learn about the claims and defenses of the other side. It includes such things as requests for admissions, requests for production of documents, and written interrogatories to be answered under oath. If you're going to do them, you need to get started. If not, then I'll close the discovery. Do you intend to do such written discovery or not, ma'am?
No.
Okay, then the court will close your written discovery. And Mr. Barter has already filed a motion for summary disposition. Have you received that motion?
Yes.
Okay, then I'll calendar that motion. That motion will be heard February 10th at 10 o'clock. If you want to file a response to that, ma'am, you should file and serve that response in accord with the Michigan court rules. We'll talk to you guys in February 10th at 10 o'clock on the plaintiff's motion for summary disposition. Your written discovery is now closed. Thank you all for coming in. We are off the record.
Thank you, everyone. Have a great day.
Be safe out there.
And I'll come back in at 10, Your Honor.
We'll come back. You mean at 11?
11, sorry. Yes.
Okay, we'll see you then.
All right. Thank you.
Raleigh wrote tons of pieces called Interior Voice of the Planet. That was my style. Some of us, you know, was to the trading like the word. It's still electronic. It's one of my favorite workshop pieces. It's 31 check suite. Raleigh. It took down the old United Artists Theater auditorium in downtown. We have to make musical amenities. And the first something with this man. Because we're, I'm talking about, we also made many recordings. From the artists of the music. The games with the orchestra. And they made that for the workshops. That's it. They're on to get so.
Morning.
Good morning.
You are on Zoom, which is what I expected. Apparently, the defendants are out in the hallway in the court. I don't recall telling anybody about coming to court in person for trial. Did I do that?
No, you didn't. You sent the
Okay.
paperwork saying do not come to court.
That's what I thought. Okay, I'll get back to you. Put you back in the waiting room.
Okay.
Okay, make sure I ain't crazy. Woodson?
He said yes.
Hello? 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 Doesn't make any damn sense.
Hello?
Yes, what do you?
Hello?
Hello?
Yes, can you hear me?
Yes. If you can hear me, you need to respond when I say hello. What is your name? Hello? Yeah, I didn't say I'd come in here. You're Donna Frio?
Yes, Your Honor. Good morning.
What is United Dumpster Rental?
United Dumpster Rental is not the case I'm on, Your Honor.
Indeed.
I am on One Stop Cash Advance.
Okay, then why does your name say United Dumpster Rental?
Oh, I apologize, Your Honor. I didn't even see that. I can change that right now.
Well, it's not that important. You're here now.
Yes, Judge.
But in the future, if you're in a waiting room with a case that's not on my docket, I don't know what to do with you.
Understood, Judge.
Let's call your file, 917. We are on the record calling file number 22 186 917.
Good morning, Your Honor. Attorney for Angelo D'Onofrio, P81836, on behalf of the plaintiff in this matter.
Mr. D'Onofrio, by notice dated December 7th, 2022, we set this matter for hearing today at 11 o'clock on the motion for entry of default judgment. The problem that I have here is your complaint seeks damages in the amount of $764, and yet your proposed judgment is for more than $2,200.
Yes, Judge. It's quite frankly, I was going to seek an adjournment of this hearing because of the fact that I needed to submit amended paperwork to this court. I was unable to do so. I would like the opportunity if the court would allow me.
How did this occur? This is a sum certain that's more than triple. How did that happen?
Well, it was based on a violation of MCL 629.52. However, and that would not treble the damages, but it's almost trebling in a sense. But in any event, the fact is that the numbers need to be amended and it needs to be in line with current precedent, Your Honor.
In line with the damages sought in your complaint as well, counsel. You just can't plead A and then seek damages for Z and X. I'll adjourn this matter for, what's today? Let's see. Today is 13th of March. I'll adjourn this matter to March 31st, sir. I'm sorry, that's the wrong date. 13th of January. I'm looking at the wrong date. Let's make that February 3rd.
Yes, Judge.
Let's get things in order, counsel.
Yes, Judge. I can submit the proposed order before the hearing.
All right, and serve the other side. February 3rd at 11 o'clock.
Yes, Judge. Thank you. Have a good day.
You too, sir.
Thank you.
February RUALI 3 2023 at 11 a.m. Motion. This is 22 186 917 113 23 P to file amended P's. Where's Simone? Hello,
Hello,
what is your name?
this is Danielle Woodson, Your Honor. Good morning.
Counsel, where are
Yeah.
you?
We're at 36.
This is, we had you guys down for a Zoom trial. Miss,
I know,
Miss-
we
Miss-
asked,
Ms. Meldrika, whatever her name, Meldrika Williams, she's on Zoom. What's going on here?
we asked at the last hearing, was this going to be Zoom or in person? And Your Honor had said in person, so we were down here, but we were on Zoom, so we're ready to proceed.
All right, then what I have to do is I have another matter.
Mhm.
And why do I have you here as a Simone?
That's one of the parties, Your Honor. That's one of the members of the LLC.
Okay. I'm gonna get Ms. Williams here and I'm gonna send you guys, we'll get another date for this. This doesn't make sense. It's unfair to have one party here and another party on Zoom.
Well, Your Honor, we're on Zoom. We're all here on Zoom.
All right, and then hang on. I have 1 or 2 more matters before you, then we'll do it.
Okay,
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 back to the waiting room.
okay. Thank
Wait.
you, Your Honor.
Okay. Barda. Mr. Barter,
Yes, sir.
I don't have your opponent as of yet,
Perfect.
so I'll put you back in the waiting room.
Thank you, sir.
All right. Mr. Barter,
Yes, sir.
my error, you're supposed to be in the waiting room.
I'm supposed to be in the waiting room.
Yep. I'll put you back there. Sorry about that.
No problem.
I let the wrong party in. I was trying to let in Woodson. There's Woodson here. Admit Woodson.
Leave me on my phone. Okay.
Oh, no, there's not. You have a hearing and it's on YouTube. So normally you would have to have earbuds to be in the hallway. So I just suggest that one of y'all keep it on since y'all.
You want to use mine because mine is not gonna work. You want to use ours?
Yeah. You know.
You seem to have some failure to communicate here.
Okay.
Okay, Ms. Woodson, should I?
Huh?
Okay, I have Ms. Williams.
Okay.
I think we're ready to proceed. You
Your
ready
Honor,
to
there
go?
is one preliminary matter
Well,
that needs to be addressed.
well, let's call the case before we begin.
Okay.
This is file number 22.
Oh, I was already in there.
Okay, just one second.
Oh, they are. Okay.
This is file 22-242-426. Mildrika Williams versus Simro Investments. It's date and time for bench trial. Your appearances.
Mildrika Williams.
I'm sorry, I didn't hear you, ma'am.
Mildrika Williams.
You're gonna have to speak louder. Counsel, your appearance.
Good morning, Your Honor. Danian Woodson, P68870 on behalf of Sinro
All
LLC.
right. It's the date and time for our bench trial. We prepared to proceed?
Your Honor, there is one preliminary matter that needs to be addressed prior to proceeding.
Counsel?
I am a receipt of plaintiff's exhibit. However, the exhibit that's labeled, or the two exhibits that are labeled 36 and 37, they have been altered from the original lease agreement. The plaintiff has whited out some of the information that was typewritten, and she has filled it in with other information that does not match the wording in the original lease, Your Honor.
Ms. Williams?
36 and 37 is, I have the original lease. This was a copy. I didn't white out anything. This is the original copy that we had signed. And it also goes with the receipts that I had sent in, far as the.
Ma'am, you're gonna have to speak up. Turn up the volume on your
It's
mic.
all the way up, sir. It's all the way up, Your Honor. It said 36 and 30. 36 and
She said
30.
36 and 37.
Yes, that was the original lease agreement that we signed for $1,250. My receipts shows
Your Honor.
when I did the money orders, that you have proof of those as well. That goes according to the 36 and 37. So if you look at the money order receipts on 35, it goes with the amount and that's in the original lease.
Your Honor, may I respond?
Of course you may.
Your Honor, this is Exhibit 36. And if you notice under paragraph 4A, it has rent is $12.50 and it's written in pen.
That's what my copy.
On the original lease, rent in paragraph A is $11.25 and it is typewritten. And that is a lease that is signed by both parties. In addition to that, this is a Section 8 housing, and the housing voucher also lists the rent for the lease at $1,125.
And the reason why that we signed a different lease, I moved in her property on May 1st. We signed the lease on April 30th to start for May 1st. The original lease was $12.50. I also have rent receipts showing that because she was holding me to the $12.50 before Section 8 negotiated the rent down to $11.25. I have rent receipts dated back that I was paying an additional $125 that equaled out to the $12.50 a month.
Your Honor, that still doesn't explain why she altered the document. As I stated, I have the entire.
Excuse me.
This
look. We're on Zoom, but everybody cannot talk at once. Ms. Williams, you will let her answer, make her response.
Your Honor, I have the entire lease in front of me with the addendums that is signed by all parties. And as the court knows, in a contract, when there are amendments made to the contract, particularly when there's something that is stricken out and another amount is entered or a different item is entered, both parties initial to show that amendment to the lease or to the contract. That did not happen here because this was something that was altered or amended by the plaintiff. It was not altered or amended by both parties in an agreement, Your Honor. The plaintiff has submitted exhibits to the court that are fraudulent and have been altered by her. And Your Honor stated several times during this proceeding that she would be held to the same standards as a practicing attorney. A practicing attorney cannot enter or attempt to admit altered exhibits to the court as true and authentic documents.
The original lease that I signed was for $12.50. I signed an additional lease to go with the Section 8. Section 8 is $11.25. I also have receipts, like I stated, that goes from the $125 that I was paying additional.
Your Honor, I hate to say this because I know it goes against what my parties say, but maybe this does need to be an in-person matter so that Your Honor can review the original lease beside the attempted exhibits.
Yeah, because we got a situation that I cannot resolve without being in person.
I understand, Your Honor.
Because what we have here is a situation where looking at what was submitted as exhibit number 30, where's I?
36.
36 here, page 36 and 37, isn't signed by anybody. It appears to be 2 pages of a residential lease agreement. And there's no signature block at all.
That's correct, Your Honor. She did not submit the entire lease, and we are in possession of the entire lease. And we do have those pages 1 and 2. And if you, again, we do need to meet in person because on exhibit 36, which is page 2 of the lease, she's altered the security deposit from 1688 to 1875. She's also altered first month's rent.
Here's what's going to happen. I thought we could do this by remotely, but these exhibits make clear I will have to have the parties in front of me, and we cannot do this remotely. All right, I'm going to put people back in the waiting room. I'm going to have to check my calendar.
Okay.
I'll be back to you shortly.
Okay. Thank you, Your Honor.
Gotta go see this.
Your Honor,
Yes.
while we were in the waiting room, if you look at Defendant's Exhibit G, page 3
Not
of
the counsel,
Huh? Okay.
we are back on the record. The court is convinced it has made an error. I cannot possibly try a case where credibility is at issue remotely.
Okay.
Simply not possible.
Okay.
January 27th at 10 o'clock, we will try the case live, courtroom 539.
Okay.
January 27th, 10 o'clock, live.
Sorry, Your Honor.
I'll send out a notice.
You said.
Thank you, Your
January.
Thank you both for coming.
Thank you, Your Honor.
We are on the record calling file number 22-187584, credit acceptance versus Jacqueline Wilson. By notice dated December 14th, this matter set for hearing today, January 13th at 11 o'clock on the motion to reinstate the case filed on behalf of the plaintiff. It's now 11:35. Could I have your appearance?
Good morning, Your Honor. Suzanne Barta, P65425 on behalf of Credit Acceptance Corporation.
Mr. Barter, the court sent notice of today's hearing to the plaintiff and to the defendant. Have you received any pleadings from the defendant?
I have not, Your Honor.
Sir, your motion.
Your Honor, today's a motion for us to reinstate the case pursuant to a dismissal. In this matter, Your Honor, we did have, we had an alternate service order that was granted by the court. We successfully served by tacking and first-class mail. Unfortunately, we didn't get the tacking back from the process server in time to get the judgment to the court before the dismissal was entered. But because we have proper proof of service, we're requesting that our motion be granted at this time.
Counsel, I reviewed the pleading submitted on behalf of your client. It appears that you made the order of alternate service comply with the terms, all the things the court ordered, posting by a court officer, first-class mail, certified mail, all within the time that was provided under the court rules. There's no opposition here. Your unopposed motion to reinstate the case is granted. We'll send out an order today.
Thank you very much, Your Honor.
Have a good day. Thank
You too. And will they also have the pretrial date?
We'll send out a pretrial date as well.
Okay, perfect. Thank you.
Thank you. While I got you here,
Yes,
what date did I give you for the other one? February 7th?
February 10th.
February 10th? Okay,
Yes.
good enough.
Perfect. Thank you, sir.
Thank you. We're off.
All right.
That concludes the morning.